Hey, everybody, and welcome to Thursday night. John Skiba here on the Consumer Warrior YouTube channel, where each and every Thursday evening we talk about debt collection, bankruptcy, debt collection lawsuits, and all things terrible as it relates to dealing with debt collection and how you can get some of these issues resolved. So, welcome to the live stream tonight. If you're new here, we do this, like I said, each and every Thursday evening, where I'm an attorney licensed in the state of Arizona. I do bankruptcy and help people who are being sued, usually by credit card companies, junk debt buyers, things like that. So we, each and every week, I do this where we answer questions. I always start with some disclaimers because that's what lawyers do, is we have disclaimers in that I can't give any legal advice. I'm only licensed to practice in the state of Arizona. So if you're not in Arizona, and even if you are, I'd highly recommend you contact an attorney to get specific legal advice for your situation. This doesn't create any type of attorney-client relationship. And so even though we're going to discuss these kind of things, it's helpful if you get some specific legal advice for your situation. If you do have a question, go ahead and put it in the chat feature there where you can put that in. I'll put it up on the screen and we can talk about it and discuss really some pros and cons to all things debt. So I wanted to start off with I've been pulling some comments from the different videos that I have on my YouTube channel. I try to respond to those. There are a lot of comments, and so it's tough to do it. But there's one that kind of stuck out to me that I thought I'd put up here. This person said that they're about $26,000 in credit card debt, currently paying the bills each and every month, making that minimum payment, but it's starting to get untenable to do this. Can I still file for Chapter 7 bankruptcy? Something that a lot of people don't understand about bankruptcy is they think that they have to be behind on their bills or dealing with a lawsuit or a wage garnishment to be able to qualify. Some people even think there's got to be a certain amount of debt. Funny enough, you don't even have to have debt to file for bankruptcy. I don't know why you do that. Although I have had situations where people are behind on like their mortgage payment or they're having a repossession, something like that. But as far as to this particular question, you don't have to be behind. I always tell people, once you make the decision that 100% you're going to file for bankruptcy, I don't know if I'd continue to pay on the credit cards. It's not going to benefit your credit score or anything like that, but you don't have to be behind. And frankly, your credit score will rebound much more quickly because you won't be falling from as far a place as you would have if all of your credit cards are behind. So that's something to think about if you're needing to file bankruptcy. It's not something where, like sometimes you hear with debt settlement that you have to be behind on your payments to be able to negotiate. Bankruptcy is not that way. I've had clients who are fully current on their bills, and then we went ahead and filed the Chapter 7 at that point. So, all right. Every week we have Marcos coming in. I appreciate their support there. He says he's still waiting for his motion to reconsider. Been in the judge's queue since August 10th. One thing you're going to learn about judges is that it's their world. We just work at it. I just work at it every day. They get to it when they get to it. There are rules in Arizona. They have 45 days to issue a ruling usually. And usually they do, but sometimes they don't. And truthfully, there's not a whole lot you can do about it. So, all right, let's jump into some questions. Lori says, I've been court ordered to arbitration with portfolio. Any advice? Part of it will kind of depend on what type of arbitration. Usually in a situation like that, in Arizona, we have what's called compulsory arbitration, where in superior court, if your lawsuit's more than $10,000, they require the parties to appear in this arbitration process. In arbitration, whether it's compelled by the court or whether it's in private arbitration, which we talk a lot about on the channel, it's really kind of like informal trial. It's not something, I sometimes refer to it as trial around a conference room table, where there's an arbitrator, and then there's the plaintiff or the creditor and their attorney, and there's you and your attorney. And then they do this, they put on their evidence, you cross-examine their witnesses, and then a ruling is issued. So you would prepare for arbitration pretty much the same way that you would prepare for trial. I have a ton of videos on that, and I put a link in the YouTube channel chat there on some of the more kind of advanced techniques and approaches I take to dealing with trial. But you'd prepare for it the exact same way. Just knowing that it's going to be somewhat more relaxed than it would in a courtroom setting. All right, Michael. Hey, thank you for supporting the channel, and I'll check out. He's a group in the. There's a Facebook group, and I do apologize that people have tried to sign up for this. It's kind of confusing. You have to sign up for our Facebook group in YouTube first, and then it allows me to give you access to the Facebook group where we can talk about these things in a little more detail. So, Michael, I will check that when we get done here tonight. All right, let's go back up to, Lori said she did live in Arizona. So yes, I'll bring that up. That was relating to the last question. Yes, you're going to be in compulsory arbitration. And what they do, they assign the arbitrator as an attorney who's been assigned to do it. It's kind of like jury duty for lawyers. They're typically not really paid to do it. But they do it as a service as part of the bar, where they will act as the judge, the arbitrator. The only downside to that is it's just pulling a name out of a hat. And so sometimes you get attorneys that are really well versed in this type of law or in courtroom procedure. Sometimes you get a corporate attorney or maybe a wills and trust attorney, and they haven't done any of this since law school. So that's kind of a hit and miss on that a bit. All right. Let's look at this question here from MG Morgan. Hi, John. How do I get an original application or agreement with the credit card company if one was signed? I'm being told there isn't one. How do I prove that? Now, usually credit card applications are, if you get a credit card, it's often applied for online now. So it may be true that there isn't a specific, like a signed agreement. Some of you may remember in the old days, they would literally send you something in the mail and you could literally sign it and send it back in, and then they'd send you a credit card kind of thing. That hasn't been that way for a long time. And so usually there isn't an actual signed agreement. And because of that, in a lot of states, like here in Arizona where I practice, that's not even necessary. They're able to prove that there was a contract just by a course of dealing between the parties where, they issued you a card, you made charges, you made payments, that kind of thing. So you may not be able to get that. As far as the terms and conditions, though, what I'd recommend is you figure out what the credit card was and just Google it. You'll be able to find it. Not only that, on the Consumer Financial Protection Bureau, their website, the CFPB, it's a government website. Again, that's Consumer Financial Protection Bureau. You can go there and they have a whole directory of old credit card terms and conditions. And pretty much all of them are there. And that's a good one. You're going to be able to get, the solid document and actually be able to see exactly what it is. Hey, Dave, thank you. Here, but a crappy signal. We're just happy you're here. We're happy you're here and that Alex is here. Always hear from Yuma. Let's go over Alex's question. Does it ever make sense to pursue litigation in defending a suit from original creditor? This is a good question. It's kind of why I created a couple courses recently on how to defend suits from American Express and Capital One. Now, most credit card companies, when an account goes into default, it's charged off, and then they will package it up and sell it in large portfolios to junk debt buyers like Portfolio Recovery, Midland, Unifund, all those guys. Some creditors do not do that, or they may not do it with all of their debt. American Express being one, Bank of America, Capital One, they will often file their own stuff. They keep it in-house. And so those cases are much more difficult to win because a lot of the defenses that we have here don't apply. As far as like them proving that your specific account was transferred, it wasn't transferred. So they're going to have the documents, they're going to have the witnesses, at least you would assume that they're going to. And so usually the only time where I recommend, like a really strong defense on those is if you're in a situation where there's like identity theft, if there's something where the balance is just completely off, if you know that you charge no more than $500 on this card and they're suing you for $5,000, things like that, where there's some pretty significant factual issues. Otherwise, I recommend taking a settlement approach. Now, that means that you may still have to file an answer to the lawsuit because you may not be able to get the lawsuit settled within the 20 or 30-day window that you have to file a response to it. But usually I try to say, those are the kind of cases it makes more sense to enter a settlement type arrangement, or maybe even something like long-term payment with a stipulated judgment. I talk about that on the channel as well, but where you can actually agree to a judgment that allows you to make payments, and then they're agreeing to hold off and not garnish your wages or go after bank accounts, that kind of thing. So those, Alex, are typically the times when I would recommend doing that. Not very many where it makes sense. I have had people recently reach out about invoking the arbitration clause. That does work with an original creditor suit because it's their agreement. I mean, when we're doing it with debt buyers, we're just doing it we're invoking the original creditor's arbitration clause. So you can do that. You can invoke arbitration and see if they're going to proceed there, and they may not, depending on the what the overall amount is and all that kind of stuff. There's one other question I wanted to deal with from the comments from videos. This person said they're dealing with Midland Funding, one of our favorite junk debt buyers, and they're trying to garnish my wages from a judgment, apparently from 2005. I see this almost every day when I come to work. People who are dealing with judgments that are super old. Some of them are so old that the courts in Arizona don't even have the records from them anymore. We're talking 15, 20 years old, and they're still coming after you trying to do garnishment. And people often bring it to me and say, hey, isn't that outside the statute of limitations? Here we are with a 16-year-old judgment from Midland. How in the world can they still garnish my pay on this? And the reason is there's a difference between what the statute of limitations and then whether the judgment is still valid or not. Statute of limitations is pre-lawsuit. It's before the filing of the lawsuit. That's the period of time from when the account goes into default, as far as how much time that creditor has to file the lawsuit against you. In Arizona, for instance, statute of limitations on a credit card is 6 years. So from the time when the account went into default, usually 30 days or so after the last payment was made, they then have 6 years to file a lawsuit against you. If they filed a lawsuit and obtained a judgment within that 6-year window, then there's a whole nother issue as far as whether the judgment's valid. Now, the judgments in Arizona are good for 10 years. In other states, it's similar. Arizona used to be 5 years, but the legislature changed that here a couple of years ago. So the judgment is good for 10 years in Arizona from the date that the judgment was entered. And then the kicker is they can renew this every 10 years. They just have to file one document. And most states are this way, where they can renew the judgment just on and on and on for the rest of your life until it's either paid or you file bankruptcy on it. So if a judgment's been entered and you know about it, I generally don't recommend just letting it sit there unless you're completely judgment proof, meaning, that they can never garnish you, they can never go after assets. Because the problem is most of these judgments have interest. Some of them have very high interest rates that they're clipping along. And all of a sudden that, you might have this Midland Funding judgment from 2005 that was $3,500 and now it's $23,000 or something. So you got to be aware that just because the judgment was entered a long time ago, they still may be able to collect on it and cause you some grief there. So that's something to be careful with. All right, let's go here with Alex. Is there a particular dollar amount debt buyers won't bother taking to trial if their motion for summary judgment is denied? No, the amount does not matter. I have literally seen, some debt buyers don't do a lot of it, but I have literally seen Midland Funding trials over $500. And I remember one time I was sitting in the back of the courtroom just watching this. There was a person defending themselves, then the Midland had their attorney, and it was like a $650 lawsuit. And I remember thinking, here we are in this courthouse. We have a judge on the bench making who knows how much. We have an attorney for the plaintiff making who knows how much. The defendant's taking time off work, and we're doing this over $600. But the reason why they do it, and the reason why they're going to continue to push it, is because if they win, in a lot of cases, they can get attorney's fees. So all of a sudden that judgment goes from $600 up to $2,500. And what I was just talking about before, the judgments can go on and on and on, and they can accrue interest. And to me, that's where the outrage is when I see these $600 cards where there's a judgment and now they're trying to collect $5,000 on the kind of thing, particularly with a Midland who's invested, pennies onto the thing. So, all right, let's see. Dave, let's see what Dave has to say. Chapter 7 discharge, June 1st. I thought it was pretty much done, but received a letter today from my Mesa attorney reminding me to send my upcoming tax returns to the trustee. Yes, this is the sneaky little way that the bankruptcy trustees, particularly here in Arizona, get additional funds for, well, they'll say for the creditors, but it's often for themselves. So in a bankruptcy, Chapter 7 bankruptcy, it works its way through the system. You receive your discharge, comes in the mail. You're all excited. It's done. But the case isn't closed yet. And as long as it's not closed, then they're still going to be administering assets. They're always going to require you to provide tax returns after you file your Chapter 7. So even if it's been discharged. And then a portion of your refund for the following year is going to go to your creditors. And they base that upon the time of year that you file. So let's say that you filed a bankruptcy in May, and then the following year you file your taxes. They're going to come after 5/12 of your return. 5/12 meaning we're in the 5th month, May, the 12 months. The rest will stay with you, but a portion of that's going to go to your creditors. So it kind of stinks. Chapter 7, it's only 1 year that they're going to take those funds. But it's something to talk to your attorney about if you're in bankruptcy, because sometimes I see people get just huge refunds. You know, they're getting $6,000, $7,000, $8,000 in their refunds, which truthfully you should be changing withholdings so that you're getting that much back. But something that's going to be a little bit tricky next year is with this third stimulus, where you're going to get, you know, they're making out these payments each month right now up through December. But then starting in the new year, you're going to get 5 months of a tax credit. So your refund may be artificially inflated, you know, compared to years past. So that's something to talk to your attorney about for sure. All righty. Let's see this. Yes, Alex, it is outrageous. I agree. I agree with you. All right. Let's see. Rick, if I can help you out here. Question about crypto. I don't know anything about crypto. Before I go any further, it says I'm considering BK7 due to a divorce and 75% household income reduction. I have about $10,000 in crypto. Should I draw that down for rent and then file, or can I protect some of it? Part of it will depend on which state you're in. If you are in a state like Arizona, and the reason why I say that is because in bankruptcy, most states have their own exemption laws that protect things like the homestead exemption for cars, household goods, that kind of stuff. And so like in a state like Arizona, yeah, you'd lose it. If you filed bankruptcy with $10,000 in crypto, the trustees would go after it, liquidate it, and give that money to your creditors. So if you were in Arizona, I would say, yeah, you're going to need to use those funds. And you can't just transfer them. You can't just get rid of them somewhere or hide them under the mattress. You can't do any of that. That's something for sure. If you're going to file, I would talk to an attorney about ways that you can use those funds so that you don't lose them into Chapter 7. In other states, they have what's called a wild card exemption. I wish Arizona would get one. But sometimes you can protect a portion of that. You know, you may have to spend down some of it. But yeah, absolutely. That's something. I see you're in California. I don't know if California has a wild card exemption or not. California is a little tricky because they have 2 sets of exemptions. And I can't remember exactly. You have to choose one or the other. So that's something that you want to take a look at for sure, because you may have to go ahead and use those funds. All righty. Well, here, Vanessa, do you offer a tutorial on how to answer a summons against Wells Fargo? Thanks for the videos. Thank you for the comment. You know, my tutorial on how to draft an answer in a debt collection lawsuit, it's generic. It'll work for Wells Fargo. It'll work for debt buyers. If you look at on the YouTube stream here on the chat, at the very top, there's a link to it. It's called How to Draft an Answer to a Debt Collection Lawsuit. It'll work for Wells Fargo, all that kind of stuff. There's some that are in there that are like tutorials that are for like how to defend American Express or how to defend Capital One, that kind of thing. Those are more like trial type strategies. But if you're just looking for something on how to draft the actual answer, that course is generic and will work on there. So, all right. I think that'll do it for today. We've got some good questions here today. I appreciate everybody checking in as always. And yeah, if I can be of help, check out some of the tutorials. If you're in the state of Arizona, you can always go to my website, consumerwarrior.com. I do practice law and I do consultations on these kind of things. Again, you have to be in Arizona, specifically if I'm doing an actual consultation as an attorney, but I'd be happy to see how I can help out. Other than that, I guess we will call it a night, but I appreciate